Okay, so let's move on to specific jurisdiction. I feel like mine cases are not glamorous, although this one is sort of. This is the case of Walden v. Fiore. This is a very fun case. You have two professional gamblers on their way home to Las Vegas after gambling in Puerto Rico. When they change planes in Atlanta, they're stopped by Walden, a DEA agent. They're carrying their gambling winnings with them to the tune of $97,000. And this makes the DEA agent suspicious. So he has his dog sniff them and their bags. The dog touches the bag with the money once with his paw, and so Walden confiscates the money. So Fiore and the other plaintiff are forced to return home to Nevada without their money. Or Nevada. I've learned it's Nevada. They file the necessary paperwork explaining that the money is legally acquired gambling proceeds. Walden, in the meantime, back in Georgia, has drafted an affidavit to show probable cause for forfeiture of the funds, and he's forwarded that affidavit to a United States Attorney's Office in Georgia. The affidavit didn't include some potentially relevant facts, such as the fact that these were professional gamblers likely to have lots of money with them. So eventually, 6 months, 8 months maybe, 6, the money gets returned. But these gamblers are pretty steamed because, according to them, they had to forego business and investment opportunities during that 6-month period that they were unlawfully without their cash. So they sue Walden in a federal district court in Nevada for violating their Fourth Amendment rights. We don't get to any of the interesting Fourth Amendment stuff here, unfortunately. Bless you. Because the case gets hung up on whether or not there's personal jurisdiction over Walden. Obviously, there's no general jurisdiction because Walden has few, if any, contacts with Nevada, much less being at home there. So for personal jurisdiction, to argue, you have to argue specific jurisdiction, which means that the cause of action has to arise in the forum of Nevada, and the non-resident defendant's contacts with Nevada need to arise from or be related to that cause of action. So Fiore argues that the cause of action arose in Nevada because they felt the harm of the false affidavit and the baseless deprivation of their funds while they were in Nevada. They relied on the famous case of Calder v. Jones that stated that even if a defendant doesn't set foot in the forum, if he targets the forum with his actions, he's subject to personal jurisdiction there. The district court did not agree. They granted Walden's motion to dismiss. The Ninth Circuit reversed a divided panel ruling that although the search and seizure happened outside of the forum, because it happened in Georgia, the false probable cause affidavit happened to Fiore while Fiore was in the forum, causing foreseeable harm through the delay of the returning of the funds. Now, you might be thinking, this is not an obvious outcome. The original panel indeed was divided, and the Ninth Circuit denied rehearing en banc, with 8 judges dissenting in 2 separate opinions. So the case itself presented a really interesting due process question. If Walden knows Fiore is in Nevada, and let's assume files a false affidavit to harm Fiore by depriving her of her money, then has Walden targeted the forum such that due process is satisfied if Nevada exercises personal jurisdiction? How many people think there is personal jurisdiction? Oh, see, me too. We're so optimistic. No. The U.S. Supreme Court, 9-0, no personal jurisdiction here. I was hopeful, but it didn't happen. Justice Thomas wrote the opinion. He noted that to have sufficient contacts, defendant has to purposefully make contact with the forum state, not just a person in the forum state. Here, Walden was not in Nevada when he performed any of the various acts he performed. Therefore, he had no jurisdictionally relevant contacts with Nevada. So this is similar to Daimler in that it represents an intentional narrowing of possibilities around the assertion of jurisdiction. The Ninth Circuit approach was novel in a sense, although it was building on precedent. But that precedent now, Calder v. Jones, has been narrowed too, and it's thought that maybe it only applies in defamation cases. There is a big question, though, and this is the one on the horizon and the one to be looking for. We're waiting for the big case where you have virtual contacts as the only contacts between the defendant and the forum. These are contacts that are based solely on internet types of contacts. Justice Thomas said in a footnote that this case was not that case, and the question was being left for another day.